psychologist Bruce Tuckman developed the familiar descriptions of group dynamic stages: forming, storming, norming, and performing. Leadership development seminars continue to rely upon Tuckman's work to explain how groups work, and the important thing to remember is that groups are not simply the sum of their individual members. The mixture of everyone together creates something independent and peculiar. Law firms are like teams or living organisms. There are moving parts and people that are responsible for each other. Partners have responsibilities to each other that are different from their responsibilities to subordinate attorneys and paralegals. Lawyers also have ethical responsibilities where they might be in a legal business relationship outside the firm structure. Hello, I'm Professor Ron McNeal, and this is the lecture series for Ethics in the Legal Environment at the University of Mississippi. The last unit of lectures examined issues related to ethically advocating for the client and ethically litigating a case. We talked about a lawyer's first loyalty to justice, even above a lawyer's duty of loyalty to the client. And now we turn back to the law office, where we will look at the firm structure and management, including the ethics of a supervising law office staff. Let's first examine the role of a supervisory lawyer and subordinate attorneys. Now is a good time to open Rule 5.1 of the Mississippi Rules of Professional Conduct. A supervising attorney is a partner or manager having ultimate responsibility for the work product of attorneys or paralegals in the firm. Personnel higher up the chain of command have more responsibility to oversee and ensure compliance with all members' ethical duties. Partners, for example, may be held accountable for the acts or omissions of equals. At a foundational level, partners in the firm must ensure that there are special protocols in place to effectuate ethical compliance. These are called quality control measures, which are intended as a sort of check and balance to ensure ethical compliance. And under Rule 5.1, partners are generally responsible for the conduct of subordinates. Rule 5.1a provides that partners have a duty to create reasonable efforts that ensure ethical compliance, and Rule 5.1b provides that lawyers with supervision or managerial authority over another lawyer must make efforts to ensure the lawyers conform to the rules of ethics. Supervising lawyers must also make reasonable remedial action if one of their subordinates violates an ethical rule. Reasonable efforts, managerial authority, and reasonable remedial action are questions of fact that will depend upon the circumstances. The procedures that should flow from these ethical obligations may differ based on the individual structure of the firm and situational practice. Larger firms will have different quality controls than smaller firms. Whatever the quality controls chosen, supervising attorneys can be responsible for negligent misconduct of their subordinates. Negligent misconduct includes acts that are not done intentionally, but that do not comply with standards of ordinary care and thought needed to fulfill relevant ethical obligations. The ethical failures may not be knowing conduct or even reckless conduct. Negligent conduct can be just oversights. Let's consider the Delaware case of Henry Freilich. In that case, Freilich was an attorney who used an independent paralegal for processing funds in real estate transactions. Closing attorneys who process real estate transactions will receive funds from the buyer of a property into a trust account, out of which the closing attorney disperses filing fees, taxes, realtor commissions, and his own fees before remitting the balance to the seller of the property. Now, several checks coming out of Freilich's office were initially returned for insufficient funds. Freilich was unaware of the issues. His wife, however, was a certified paralegal, and she discovered these issues, which were remedied and voluntarily reported. Even though Freilich misconduct was committed by an independent paralegal, it was not known to Freilich himself, and it was reported and remedied as soon as possible, Freilich was still responsible for the negligence. So the State Bar Ethics Committee found him merely negligent and gave him a public reprimand. Partners and managers often serve as supervisors of subordinate attorneys, who must report to the supervising attorney, who then takes ultimate responsibility for the work product's compliance with the firm's ethical practices. Supervising attorneys are held more responsible for acts and omissions of subordinate lawyers. Supervisors are required to make reasonable efforts to oversee subordinates. Procedural protections are not enough. Supervising attorneys must take an active role in overseeing those attorneys. What exactly does this look like? If you're familiar with apprenticeship models, you'll know that masters of the craft review the work of the apprentice. There are many ethics opinions in cases addressing inadequate supervision of subordinate attorneys by supervising attorneys and the potential responsibility a supervising attorney has when a subordinate commits ethical errors. Consider a 2004 District of Columbia case styled N. Re. Cohen. This case deals with some rather complicated facts surrounding a conflict of interest, but the important point is that Cohen was the principal in a firm and his son was a subordinate lawyer working on a trademark case. The son committed a number of ethical violations. The question is whether Cohen, the supervisor, is responsible for the acts or omissions of his subordinate. In Mississippi Rule 5.1b, that says the supervising attorneys must take reasonable steps to ensure that subordinate attorneys conform to the rules of professional conduct. The court in Cohen applied this principle, saying, considering the discrete nature of the case, the extended length of the representation, the small size of the firm, and of course the degree of supervision or lack thereof, a lawyer of reasonable prudence and competence would have made the inquiry necessary to prevent the younger Cohen's ethical violations. This responsibility for active supervision needs to be contrasted with another legal concept called vicarious liability. Vicarious liability means that a principal is responsible for the acts or omissions of an agent. In a law firm context, the professional relationship between supervisor, attorney, and subordinate does not create vicarious liability, but imposes an ethical duty upon the supervising attorney. So a partner in a firm might be implicated in an ethics complaint involving a subordinate, but will not necessarily be liable in a civil trial if the subordinate's failures or violations rise to the level of a negligence lawsuit. A supervising attorney may, however, be liable in tort law if the supervising attorney fails to avoid or mitigate tortious conduct, directs tortious conduct, or condones tortious conduct. You should know that supervising attorneys may be ethically implicated where they knew about misconduct of a subordinate or not, but will usually be subject only to possible civil liability for misconduct of a subordinate if they direct, condone, or fail to mitigate misconduct. Essentially, this is a self-policing system. Our rules of ethics impose positive, affirmative duties on supervising attorneys to review the work of subordinates and imposes ethical sanctions for failures to do so. Lawyers also have ethical responsibility for the acts or omissions of non-lawyers in their employ. The obligations in that relationship are the subject of our next lecture. So, until next time.